Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another episode of Legal Tea. Today's topic is a current trend, something going on in the current time that is pertinent to my little estate and elder law world. So for today's episode, we're going to be talking about rental properties. Does anyone else out there feel like everyone and their brother are buying properties to rent out? I have several clients that I hear from a few times a year, and they're telling me every time that they've bought another rental and that they need to add it to their overall plan. And on top of that, I see posts on social media from my own friends and family. Oh, here's a Facebook status, bought 123 Apple Street, and we're going to flip it and rent it. Yay! That's why we're going to be talking about it today as a current trends episode. This may be obvious and remedial, but individuals buy rental when individuals buy rental properties, those are assets. And what does an estate plan deal with? Assets. So rental properties in your estate plan are very, very intertwined. I'm amazed how many times that I meet with clients, and when we dive into their assets, they fail to list a rental property. And then like mid-conversation, they'll mention the rental property and I'm like, wait, what rental property? So with rental properties, I think there are two major things that we need to discuss within the realm of estate planning. First, how should you own the rental property? And second, how does it get incorporated into your estate plan? So let's tackle them one by one. So first, how should you own this rental property? For starters, if you have rentals and they are in your name, do not raise your hand. Just listen nice and closely. Having rentals in your name individually, as in the property, like as if the property ownership is, say, John and Jane Smith, that opens you up to an immense amount of liability. We live in such a litigious society, and people sue people all the time. So it's wise for all of us to protect ourselves, right? The answer is yes, unless you just love to open yourself up to liability. The issue with rentals are primarily your tenants. If they fall down some uneven front steps, are you liable as the property owner? Or maybe you fall short as a landlord according to landlord-tenant laws, meaning you owe the tenant some duties under the law. Are you liable as the property owner? Or say there's a dispute between a provision and the lease. Are you liable as the property owner? You know, the handy-dandy thing is that sometimes rental property owners get adequate insurance coverage. The issue is, what if the tenant wins and the insurance coverage isn't enough? Are they able to come after you personally? According to a blog by Padula, Bernardo, and Levine, a law firm in Florida, it's recommended that rental property owners actually place ownership of the rental property in a business entity. I agree. I see this done quite often. I do it quite often for my own clients. Here in Indiana, and as the blog suggests, so in Florida too, a very commonly used business entity, especially for rental properties, is an LLC, otherwise known as a limited liability company. Because the LLC is separate from the individuals, it provides the individual's personal liability protection against those tenants. And as the blog suggests, when you use an LLC, you actually move the property ownership into the name of the LLC. Instead of the property ownership reading John and Jane Smith, it reads whatever they name their LLC, LLC. So if they name their LLC the John and Jane Smith LLC, the property ownership is the John and Jane Smith LLC. If a tenant sues and succeeds in the lawsuit, Having the property in an LLC protects the individual's personal assets with the exception of the LLC property, meaning the rental property. What that all means is they could come after the LLC, the rental property, but not the individual's other personal assets. So if you have rental properties and do not have an LLC involved, I'm sure you may be thinking, okay, Jenny, you convinced me. How do I set up an LLC then? Well, you have two options. The first option involves setting up the LLC by yourself without professional assistance, like an attorney. You can do that, sure. You'll just need to set up the LLC with your state. Here in Indiana, we go through the Indiana Secretary of State. And within the Secretary of State, they have what they call a business services division. And that's where you go. So once you get that set up, you also have to obtain a tax ID number called an employer identification number, and you obtain that through the IRS. Once that is obtained, you'll need to create an LLC bank account. And that all sounds fine and dandy, right? Well, you should know, here on Legal Tea, you all know that if it sounds too good, there's something you're missing. So they teach us a little thing in law school, and it's called piercing the corporate veil. If you ask any attorney what piercing the corporate veil is, they've definitely heard of this term of art. What it means is if you make a single mistake in the business creation or even the business management after it's created, that tenant's attorney they may be able to pierce the corporate veil and attack your personal assets. So could you set up your own LLC? Sure thing. Just make sure you have the thing set up correctly. Oh, or say you're like, okay, Jenny, fine, I'll get professional assistance in getting this LLC set up. So most estate attorneys and even some accountants can help you get an LLC created and make sure, and in doing so, you kind of have the peace of mind that it's done correctly, right? Because you have a professional involved. Though when the attorney, if I'm involved in setting one up, I often recommend something called an operating agreement, in addition to getting the things set up. The operating agreement is what details things like who is in charge of the LLC, like who's the manager, when should the LLC members meet, how are LLC interests transferred, what happens if a LLC member passes or becomes incapacitated. That's the document that provides all these nitty-gritty details about the LLC and how it's going to work. Without an agreement, there sure is a lot of gray area. I hope this last comment, before I shift into how we incorporate rental properties into your estate plan, I hope this last comment does not make your brain explode, rental property owners. But to provide the most protection for yourself, it actually may be wise to have a separate LLC per rental property. And it makes sense when you think about it. So say we have, if tenant Bobby, so we're gonna have a tenant that is named Bobby. Say tenant Bobby sues your ABC LLC, which holds ABC Street rental property. Tenant Bobby can only go after ABC Street rental property. Though if you put all your rental properties into ABC LLC, tenant Bobby can try to attack all the rental properties within ABC LLC. So when you have separate LLCs per rental property, you're essentially separating liability per LLC and per rental property. And I get it. It sounds crazy and redundant and annoying, but it provides the property owner an immense amount of liability protection. By the way, yes, this means every LLC has its own bank account. The tenant should pay the appropriate LLC bank account, etc. Otherwise, if you fail at the management of the LLC, you are at risk of the tenant being able to pierce the corporate veil, which, remember, is bad, bad, bad. That's when the tenants can possibly attack your personal assets, which is like the whole point of having an LLC, is to protect those personal assets. Alrighty, shifting to the second question here, which is how does your rental properties get incorporated into your estate plan? As I said earlier, the rental properties are your assets, even though they may or may not be in an LLC. And as such, your rental properties and estate plan should play nice with one another. To deal with this question, we need to talk about 2 points in time: incapacity and death. When I say incapacity, I'm talking about like cognitive, mental incapacity. So due to, say, something like dementia, or a physical incapacity, like you're in a coma. The thing to remember for this is you're still living, but you cannot manage the LLC stuff, either temporarily or permanently. It really depends on whether, to tackle this issue, it really depends on whether you have a living trust involved or not. The benefits of having a trust involved is to, 1, avoid the probate court process, and 2, minimize estate taxes if it's applicable. If there is not a trust involved, you definitely need to have what's called a general durable financial power of attorney, which will grant someone else to manage your legal and financial affairs if you're unable to do so. Without a power of attorney, a guardianship court process may be necessary to grant someone authority to deal with legal and financial affairs. So having a power of attorney is sort of like a bare minimum if you have a rental property or LLC involved. Otherwise, if there's not a power of attorney in place and something happens to you, we may be looking at guardianship, which is costly and it is not fast or efficient. Then, still on the whole, no living trust train, if you pass away with the LLC and you do not have a last will or testament, or all you have is a last will and testament, it is quite likely that to get someone legal authority to deal with the LLC at your passing is going to require the probate court process. This is because a power of attorney terminates at your passing. So that document is no good anymore. And the baton shifts to the executor, or as in Indiana calls it, personal representative of your will or estate. Without going through the probate court process, no one technically has the legal authority to deal with the LLC. This is why many people who have rental properties in LLCs, especially if they have LLCs, have a living trust involved to ensure probate is avoided. As the blog by Padula, Bernardo, and Levine mentions, quote, "You can also choose to make a living trust the owner of an LLC that owns rental property, combining the LLC's asset protection benefits with the trust's ability to avoid probate, minimize estate taxes, and allow for management of your assets if you become incapacitated," end quote. So a trust offers so many benefits that it can deal with if you become incapacitated and upon your passing. It not only deals with both points in time, but it also provides benefits, as this blog suggests, like probate avoidance, and in some cases helps minimize taxes after you pass. As we wrap this episode up, if you have a rental property and it's not in an LLC, Or you have a rental property in an LLC but aren't sure if it's set up well, reach out to an estate attorney. And if you don't have your estate plan set up, get that set up appropriately too, so your LLC and estate plan can play nicely with one another. If you're anything like me, I have so many clients, family, and friends scooping up rental properties, so feel free to pass this episode along to them to make sure they're protecting themselves before it's too late. Alrighty, let's wrap up this episode. Next week's topic is on estate planning of the rich and famous, and on that episode, we're going to be talking about Kurt Cobain. And if you've lived under a rock and don't recognize his name, he was the lead vocalist and guitarist in the band Nirvana. So for any of you Nirvana fans out there, or just generally rock fans, next week's episode is for you. So we'll talk about Kurt Cobain next Tuesday, Legal Tea listeners. Talk to you then, and stay well.